Hello, my beautiful friends. This is the Time to Care Like Caregivers podcast. I'm Isabel, your host, and I'm delighted to introduce you to Arma Fitzgerald. She is an estate attorney. So she sees everything about wills, trusts, all of those things that I'm not an expert on, but today I'll learn more about it with you. Welcome, Arma.
Hi, Isabel. Hello, everyone. It has been a pleasure connecting with you, and it's a pleasure recording and having this session with you, Isabel. Thank you for including me in your podcast.
It's lovely having you here because I know usually attorneys are so busy all the time that it's hard to catch up with any of you.
We made it work, and I appreciate you for being so patient.
Yes, it took a while for us going back and forth and finally getting some time to record this. So tell us more about yourself. It is your time to shine.
Yes, there we go. So as you mentioned, my name is Arma Fitzgerald. I'm an estate planning attorney in 6 states, licensed in 6 states. I do will, trust, asset protection, some tax planning, and also probate. My actual location is in Dallas, Texas. I'm Texas-based, but I'm licensed in other states as well. And I'm a mother of 2, which is extremely important. I have 2 fine young men, boys, teenagers. And I'm also the founder of Estates Armor. That's my firm. And I already talked about what my focus is.
So what is the difference between a will and a trust? And are there any other instruments people can use in their lives?
That is a great question. We're going back to estate planning 101. A will and trust, both are great. There are pros and cons to each. So will is basically a document, legal document, where people write their last wishes about what they want to see happen after they pass away. Trust is, again, an estate planning tool, which is more complex than a will, but it also does a lot more than a will. In a will, when you have a will, it's better to have a will than not having it. But a will only comes into play when a person passes away, dies, meaning that if someone, which about 80% of Americans, they become incapacitated at one point, whether it's temporarily or permanent, a will doesn't do anything about those situations. Like you can write down, I wish the money for my care be used from this account, or somebody do X, Y, and Z if I cannot do it, but it won't happen if it's in a will, because a will comes into play when a person dies, right? A will is great to have it, it's better than not having it, but there is a misconception. People think that if they have a will, they are protected and they can avoid probate, which is exactly the reverse. If you do not have a will, or if you have a will, then it's almost guaranteed that you will have a probate. And the reason is because the will has to go through the court and in front of the judge for the judge to determine that this will is valid, is legit. So it wasn't just handwriting from a family member deciding to make decisions for your assets. So, and probate is a lengthy and can be a very expensive process. During the probate, all the assets are frozen, so the loved ones don't have access to them. So if it's a case where they actually have to use the assets to pay for the probate, they won't be able to do that until the whole process is done. And they have to make any decisions they want to make. If they want to access the assets, any of that, it has to go through a process. The court, basically the judge, has to give that permission. So that's why it makes it very lengthy, cumbersome, can be expensive, and it's public. So if you like to live a private life, you don't want people to know what your assets were and who your beneficiaries are, will does not give you that. It's actually public. People exactly know, predators and creditors will know who you were, how much assets you have, what kind of assets and how much money you had, and also who the beneficiaries are and who got what, who received what. So, and the reason for the will that needs to go through probate, one of the reasons is because if there are any money owed by the deceased, Then the court does an inventory. They actually assign it an attorney. If the will already assigns an executor, which is a person who will take care of the affairs after the client passes away. If not, the court assigns an attorney to walk you through the process. And then all the assets they go through an inventory, they're appraised. Any money that is owed to any creditors will be paid first, and then whatever remains will go to the beneficiaries if there are any beneficiaries in the will.
What happens if can I just say I don't want any beneficiaries?
You need to designate where your money, your assets will go. Like it can be a charity of your choice. Or if you don't pick anybody, then the court will decide what happens to your assets. It's the same as if you don't have a will, we all have a will. It's just a default law in our state that applies to it. So if you don't have a will, the court decides what happens to your assets based on the default laws of that specific state where you reside. Another thing about the will, which thanks for that question because you reminded me of that, is will is connected to the state laws. So people who travel, if you have a will in one state and then you move to another state and God forbid pass away in another state, you're going to have a problem because if you haven't updated your will to match the laws of that new state, then there's going to be an issue. So that's another thing. But if you're interested in privacy, not paying too much money or wasting too much money from your state, you want your beneficiaries, your loved ones or siblings, whoever is going to benefit from your estate, to access the assets quicker. And if you want to be able to travel everywhere, anywhere you want to go, then the will is not the proper answer. And also, if you want to plan for incapacity, then the will is not the proper answer. We need to look at a trust. A trust is like a package. If it's done properly, it's like a package. It includes the last will and testament. It includes the rest of the ancillary documents that if there are statutory requirements for a state, if a state has a statutory requirement, then the state plan package also includes those documents. And then in a trust, you can decide exactly what happens to your assets long after you're gone, how your beneficiaries will receive them, how much, when, and how. So it's like a set of instructions that you control everything before you pass away. You set the rules, and the rules apply after you're gone. And also in there,
How exotic can the rules be? Can you say like you're going to go through a gladiators
so
battle or
I see some really, I shouldn't say crazy, some really detailed and interesting rules that clients decide to have. Like if they have several kids, for example, they find out one of the kids, they're all minors, but they already know that one of the kids is not going to be able to manage their money. They can set, for example, um, some of the kids, they get their assets either outright at a certain age or get portions of it at different ages or receive it in a trust, which is a lifetime asset protection trust for children, which remains in the trust, is protected from creditors and predators for the lifetime of a child as long as the assets are not taken out. And then they can determine that one child, we want to keep everything in that trust with a co-trustee and to benefit the child for the lifetime of the child, but the child cannot touch it. So it can be that, or you can actually set up a trust to protect your animals. So when you pass away, if the family members cannot decide on who's going to take care of them, you can even set the rules on keep the house, don't sell the house until or as long as my pets, my fairy children are alive. Then after they pass away, do A, B, and C, or they can even put a special amount of money or a percentage of money aside for the care of their animals. I mean, you name it. You just tell me, give me some examples, and I'll tell you if it's doable.
I want to know if my beneficiaries could fight in a duel.
So I had one that was a rock, paper, scissors long ago. If they watch this, I know they are going to laugh because I was like, "Are you serious? You really want to do this?" And well, given they're not their children, they are relatives, but still, we set some rules, and at the end, they were like, "No, we want to do that." I was like. And they were like, we want to make him laugh. And I was like, if that's the purpose of it, I don't recommend it because you don't want to create family feud. But I'll be happier if they set like 2 or 3 rules first. And if those don't apply, then we can do whatever you want. And that's what we did. So yes, you can. But as an attorney, it's my job to advise my clients to make the most prudent decision, and which is trying not to get your family members to fight with each other or potentially harm each other.
Well, if they're already in a duel,
Yes.
I think that would make things real fun.
I mean, there's so many more civil ways to get to the same result. But anyway, yes, I do hear very interesting requests. And again, as an attorney, I make my suggestion. What is a proper way to approach it? What is a prudent approach? And then if they also wanted to add that, yeah, sure, we can do that to make him laugh. Not to take it serious, but make him laugh.
Okay,
So
I'm gonna designate colors so everybody coming, they're
yes,
gonna have to start wearing certain colors starting on my funeral day.
you can do that, but then it would be actually fun if you organize it well, but then at the end, actually set up some rules.
That's gonna be the rule. If you wear this color for the next from the day of my funeral until the assets
My goodness.
are
My goodness.
are delivered to you, you're gonna get an additional whatever.
Then you have to make sure you designate a person to be able to monitor that. So the trustee of your trust, which you have to set up a trustee. The trustee is a person who will manage the trust. The trustee has to be aware of that and also be able to monitor that. So what was I trying to say? Also in the trust, I have clients where they say, I don't want my kids to become trust fund kids. I wanted to try hard. So anything that is left, I don't want my kids to get anything. I wanted to go to my grandkids in a separate trust and used only for their education. So we can do that as well. So truly, with the right estate planner, there's so many tools available that the client just has to communicate their wishes, and then we'll try to find the proper way to make it happen and keep the client happy. Another thing with trust is you can also plan for your incapacity. So if you, God forbid, you get into an accident, for example, and then all of a sudden you cannot talk, you cannot make decisions, which can be temporary or permanent. You can set the rules on what's going to happen to you. Who's the decision maker for your finances? Who's the decision maker for your well-being as your guardian? And all of that. So your loved ones don't have to go to court, fight with each other over who will make those decisions for mom and dad. So there's so much you can do with a trust. The way we do it in our office, we don't charge per hour or per document. It's a flat fee, and we do it in purpose, and we include everything in packages. And we do it in purpose because I personally want to make sure my clients feel comfortable to truly share everything they need. They don't have to worry about, oh, I went over 30 minutes of my time or an hour, I'm going to get charged more. Or I don't want to include this document or that document, which all these documents are necessary. And then, I don't want my trust, basically. I tell all my clients, I do not want my trust to fail. So that's why I have a package. And if they can find an attorney who does the same, downside of trust, let me go to that first. Downside of a trust is because it's a complicated process, just a regular family attorney or just a general counsel, it's not something that they can know all the rules and nuances to be able to design it and execute it and draft it properly. So they need to talk to an estate planning attorney with experience where the attorney's focus is estate planning. We have so many conferences and educational sessions just for little nuances that change. When the laws change, little words can make a difference. For example, for elder law planning or special needs planning, little tiny words can make a difference between the person becoming eligible for government-based benefits or not, or lose it. So all of these little details matter. Or certain documents, for example, in Texas, we have the statutory documents that we have to make sure it's included in the package. So downside of trust is it's better to talk to estate planning attorneys. Focus of their firm is estate planning. And then also it would be good if clients search and see if they can find someone who has more of a flat fee packages versus hourly, because again, estate planning process is very complicated. And if they want to make
Especially
sure
when you start putting duals into it.
uh really that, because you have to make sure you don't cause trouble legally. You don't just cause trouble for your beneficiaries where they'll, like, God forbid, go to jail. So
Yeah, you don't want anybody dying during
no, you don't. You don't want to do that. You don't want them to say, you know what, I should have just, gave up on that inheritance. I would have been better off. So no, you don't want to do anything illegal. So yes.
So, okay, so you either pick one or the other. What are good questions that you might want to ask your attorney before you meet or during your meeting? Like, if what are things you wish your clients knew before they meet you?
Let me tell you, let me change your question just slightly. So let me talk about the clients that go to the attorney who doesn't have experience and then they come to me. First of all, I wish initially, the initial wish that I have is for people to realize that the only thing in this life that we cannot really have control over is when we depart. And I wish they would at least give it a little bit of time and do some research and figure out, at least think about this question, close their eyes and think, what if tomorrow I won't wake up, God forbid? What's going to happen to my life, my hard earned money, assets, loved ones, children, whether they're minor children or adults or grandkids, my spouse? I see so many of those cases where there is an estate plan. It's not done right by the proper attorney, and the documents are either too old and they were not updated, or they were not designed properly. So then there's a second marriage, and the ex is actually the beneficiary of everything. And then the new spouse or the second marriage, it can be like, I've seen some cases where they've been together for 30 or 40 years, but then the new spouse, and children from the current marriage don't get anything. And I also have cases where there's a second marriage, Brady Bunch situation. There is no estate plan, or the estate plan was not done right. Therefore, the new spouse and children get everything, even the photo albums. And the child from the previous
Why
marriage,
would they want photo albums
memory.
from another marriage?
No. The children from the previous marriage, they wanted to have access to their photo albums with their dad.
Yeah, but if that
No, when they were
goes,
children.
yes, but like my question is, why would you want to keep a photo album where like that part of your life was not there?
No, so this, let me go into details. So one of the cases, the son from the previous marriage, they had a great relationship. He wanted his photos with his dad when he was a child. The father had the photo album from his childhood.
Hmm.
Okay, so It was his photos when he was a child with his father.
Yeah.
But then the state plan was not designed properly, and the new spouse received everything, didn't give him anything, not even the photo album that belonged to that son.
That is my question.
So you're asking
Why would she want to keep
it was not that
the
she wanted to
baby
keep it.
album of someone who's not even your
It's
child?
not that she wanted to keep it. She just didn't want him to get anything.
Lame.
But you will be surprised how many times and how often I see that.
Yeah, but I just want to make people be aware how many times we don't give logic to the things that we do, and how many times we just act to spite others or to make them angry or to make them feel less. And I think that is exactly the point of why this is important.
Precisely. One of the main reasons that it's extremely important to just keep peace of mind for yourself while you're alive, and also for your loved ones after you're gone. Because why not? You can do it now. You can plan it now. You can do something now. This is your last love letter to your family and your loved ones. Why not write it now while you're alive and have mental capacity and do the right thing? So when you're gone, everybody's happy. Maybe not everybody is smiling big because they didn't all receive the same amount of inheritance, but at least they won't fight with each other because they know mom and dad made these decisions. It has nothing to do with the siblings, right? Or it has nothing to do with
Yeah.
the second wife or the ex-wife. It's just the deceased person made those decisions, right? So there's no
Yeah.
family feud, unnecessary court costs, and it takes time. When you get court involved, courts are backlogged. So it's not like you ask, and it's expensive because you have to get an attorney to go through the process. But why?
Yeah. So, what are other things that people should know before contacting either you or any other attorney?
So I talked about it a little bit. Doing a little bit of research, for example, choosing the right attorney. With technology, Google reviews, Chat GPT, or any of this technology, just do a little bit of research about just, you can even ask what you're trying to accomplish. What kind of attorney do you need? Who is the proper attorney? Who has good reviews? Who has, the experience or specialty? Just spend just a little bit of time to find answer to those questions. And then my suggestion is, when they find, don't rely on just one attorney. Just make a list of like at least 2, 3, or 4 attorneys and take the time to at least give them a call and to see if you have the right connection and you're the right match. Because sometimes it can be the best attorney, but if you cannot communicate with each other, if that attorney cannot understand what you're saying, and you don't feel comfortable talking about wishes or what's going on in your life, it's not going to do any good, right? Like, talk to them and see, like, come up with a scenario that relates to your situation, your family, you know, dynamic. And say, okay, what would you do in this type of situation? If it's like a single parent, just got a divorce, received a settlement, wants to save it to benefit him or her for life, and then also help the child. What if I want to disinherit a person and I want to make sure that person doesn't get control of or make decisions on my finances or my well-being or my children if I'm incapacitated or if I die? Because I see a lot of those cases as well. They don't make those determinations, and all of a sudden the wrong person is in charge of the money, finances. The wrong person is in charge of the client's well-being while the client is incapacitated. The wrong person is in charge of, the court assigns the wrong person to be in charge of minor children. Sometimes there are family members that the children have never met, but
My
that was
goodness.
the best choice by the court. Can you think devastating, the terrible it can be for a child that loses mom and dad because they decided to go overseas, travel overseas, which good for them, but God forbid something happens. Not only they lost their parents, but also now they're child protective services, because that's the first thing. If you do not have proper documentation, I have to add that. When you have minor children, if God forbid something happens to both parents, then the Child Protective Services comes and removes the children from their home and takes them until someone is assigned as the guardian of the children. Sometimes it can be a temporary guardian or temporary plus a permanent, but that also takes time, right? So the court has to make those decisions. So the child has already lost their parents. Think about how scary that is. These strangers come in and remove them from the house, right? Take him into custody. Then there's a period of time for the court to determine who else is related to them. Then those relatives have to fight over who will have the custody of children, right? And then all of a sudden you end up with someone that you may never have met, or you have bad memories. But then the court doesn't know, right? And then they give the custody, and those just, you know how terrible that is? I've never met anyone who wished that upon their minor children. So these are the things that I wish people would think about and not procrastinate and think that, oh, I'm going to be fine. Oh, I'm still living. Oh, I'm still breathing. Yes, this is actually the time to take this serious and make these decisions, truly write this last love letter for your own peace of mind so you can continue living another 100 years and don't worry about it. Although you need to update all the documents every few years. But then also it's a peace of mind for your loved ones. If
Yeah.
you need it, it comes into play. It's a lifesaver. And if you don't need it, at least you know you had it, right?
We were talking before we started recording about me being on the phone with Tracy. And
Yes.
for everybody out there, Tracy is a friend that we have in common who was super kind, and she introduces both.
Exactly.
And Tracy has also been in the podcast, so go and listen to her. And one of the things that I was telling her that I need to trust a will, because I know mine won't be good in the US. And she was talking about it, that she needs to update hers because all the work that she had done was for the time when her kids were really young. So now they're all older than 18, they're adults. And now she's living in Texas. Back then she was living in Pennsylvania. And I didn't know that that didn't apply. So I'm gonna text her after this and just let her know, hey, by the way, you want to hurry that up, like you want to move that, make that faster, because your trust or will is not valid anymore.
And the trust, all that will doesn't need to be updated. Every legal document needs an update every few years because the laws change. Family dynamics change. People die, people are born, they're minor, then now they're adults. They're planning to get married, children planning to get married, but it's kind of a rocky marriage. And you're like, do I want to leave my son's inheritance, give it to him outright, when I know if they get a divorce, half of it will go to the ex? I don't think you want to do that, right? So all of these changes in a family dynamic, when they happen or if they are anticipate them, it should be talked and discussed with the attorney to make sure the documents are alive, reflect the family dynamic now, and hopefully for a few years after, right? So, like a will, you have to update it when you move state. You have to update it every few years because things change. A trust is the same. It has to be updated every few years. So, if a trust, that's my rule of thumb. If your trust is about 10 years or older, I'm not even going to review it because it's going to cost more for me to sit down, charge you hourly for reviewing your trust versus starting a new one. With the packages, it's not as expensive, right? It's affordable.
Mhm.
So it's better to do it that way. So both of them, they do need updates. We have other resources also. For example, as you mentioned, Tracy, and having minor children, now having adult children, setting up a trust within the family trust, which is called a lifetime asset protection trust for children, to make sure their inheritance is kept and protected, benefits the children, but is kept in one place in a trust and is protected. It's a way to go. in my opinion, I suggest it to my clients because you don't know. There might be adults, they may get into a car accident and then all of a sudden there's a lawsuit and they come and look and see, oh, you just inherited this lump sum of money. So you know what? My client just developed this back pain and the headache and all sorts of other pain from that accident. You just want to avoid that. It's just why not? If you can do
Yeah.
it now, why not? Just do it. And then
Yeah.
also
And
other
I was commenting to Tracy that when we went through my uncle's passing, there were so many people that pop up out of nowhere
there we go.
asking for money. So it happens, it is real. And every time that someone receives money, someone's going to be there wanting a piece of that.
Yes, and that is what I see with my probate cases. Oh my goodness, you're just like talking about the type of situations I have to deal with on a daily basis. And I love it because each client is different than the other. On the surface, they may look like they have similar lifestyle, salary, number of children, right? Or the type of marriage or the type of house or cars. But when you get inside the family dynamic, they're very different. There's I haven't found two cases that are the same. They're always different. That's actually why it's important to make sure you talk to the right attorney because then the right attorney has access and knowledge of all the tools to be able to customize your estate plan to who you are, not your neighbor or your brother sisters. So thank you for bringing that up. You're just talking to my soul.
Yes. Yeah. Because we lived that.
And the
And I
probate
know it happens. Like every time someone wins the lottery, that person is going to get a bunch of lawsuits from people that probably they have never heard from.
kind of a similar situation.
Mhm.
And then probate is in general lengthy, really cumbersome process. Unless there's maybe just one asset or minimum number of assets. Otherwise, you are right. All of a sudden, there are children that nobody knew they existed, but they pop out of nowhere. That was another case that I was consult. It was a consult. It's not. We didn't sign a contract, but now we found out there are 8 children instead of 2, and it's cumbersome because they have to fight. And when there's a fight, even if you're right and the other side has no documents to back their position, it's a fight. Meaning that if they have an attorney, you have to hire an attorney or you lose even if you're in the right position. I've seen so
Yeah.
many of those. And then you have to pay the attorney. So if the other side keeps sending letters, you have to have an attorney, and each time an attorney responds, there's an expense for you. It's not fair, but that's how a fight is. Until you have
So
a way on.
you want to hire Armo. So where can people find you?
I greatly appreciate you saying that. Would love to have an opportunity to help as many people as we can. My firm that I'm a founder of it is Estate Armor. And you have, I believe you have access to the website, the link, and that's how to find me. And our process is very simple. It's transparent. The clients are actually involved with the process. It's not like I tell them this is what you need and then draft it and hand it to them to sign. They will be engaged in the process and they will receive updates on where we are, and we constantly communicate and ask questions. What would you like to do if, God forbid, we call it a Thanksgiving family turkey explosion, where God.
Which is, by the way, around the corner from this
Yes.
recording.
Well, not to scare people, but it happens. And then in that case, who do you want to take your estate, your assets, right? So even we talked about those details. Who, how much. Charity. You want to give everything to charity because you love animals, you like to rescue animals. You want to give it to your church, you want to give it to your children's school because you really believe in education. Doing a trust properly done right, it's a way to do it, not a will. So yeah, any we love to help people. So
Yeah.
Estate Armor is my website. That's my firm. And we have a very simple, easy, transparent, and quick. Doesn't take us months or years to create an estate plan. From the start to finish is usually between 6 to 8 weeks, unless something happens or the client doesn't really communicate, doesn't stay engaged, or things happen in life, Otherwise, it's usually 6 to 8 weeks and it's done.
Okay. Anything else you want to share with us?
What do you think your viewers will benefit from? They would like to know. Would you like me to just go over major documents that people should have?
I'm writing a book and I'm starting right now. So one of the prompts that came is if you could stand in a crowd and say a sentence, what would you say? So I'm passing that to you.
Thank you for that. What I always like to say, share, and remember for myself in different situations is always face the sunshine and the shadows will fall behind. That's my thing. And I hope everybody would do the same. Stay positive, take the proper actions now so you don't have to fear anything. All those shadows, darkness will fall behind and you always face the sunshine. You become the sunshine yourself.
Thank you so much, Arma, for your
My absolute
time
pleasure.
and all the knowledge that you shared with us today.
Absolute pleasure. Absolute pleasure. Thank you so much. You take care.